Is this any better? Can people hear? Okay. All righty, we're starting, everyone. So I want to welcome you to the first ever Fireside Chat, sponsored by the Environmental Law Section in honor of the winner of the Lifetime Achievement Award. And this year it is E. Clem Shute, Jr. And first, a few introductions. My name is Marilee Hansen, and on the other side of the fireplace is Mark Lucebrink, and we were the co-chairs of the subcommittee that vetted the nominations. It was a very tough job because every person nominated was, to use an overused word, awesome. So it was really a tough job, and it was very humbling. Just like it is when you review the scholarships among students who apply. It's really humbling to see all the achievements that these people had accomplished. Now we will go to the actual fireplace. And in center we have Clem. And then we have Jane Crocia and Tom McHenry. They are both advisors to the Environmental Law Section, and they served on the subcommittee that vetted the nominations. Jane is also a former chair of the Environmental Law Section. We're passing around cards. Tom and Jane worked very closely with Clem on developing the questions, and they're going to lead the discussion tonight. Nonetheless, you may have a question that doesn't get asked, and write your questions down on the cards. Mark and I will collect them and hand them to Tom and Jane. And if there's time at the end, Clem will answer them. You'll see the cards are color-coded, and that's because we're going to figure out who asked what question. But don't worry about it. If they don't have time to get to the questions, every person that wrote a letter recommending that Clem be chosen for this talked about how friendly and accessible he is. So I'm going to trust those people and say that if we don't have time to address your question, approach him tonight and ask him your question, and he told me that he will be receptive to talking to you.
Just bring me a glass of wine.
So don't be intimidated. The other thing about the cards is this is the first Fireside Chat we've ever done. So we appreciate you coming, and we also would love to hear recommendations on how to make it better. So write down your suggestions on the cards, or come up and talk to one of us, email the bar, whatever works for you. But we do want to continue to make it a better event each year. Finally, a couple housekeeping requests. Number one is this is being taped for posterity, and it's going to get noisy out there, so we would appreciate you keeping the chit-chat with your neighbors down to a minimum, and also try not to walk around too much. Finally, I just want to say that we really thank Clem for being willing to do this event, because one of the drivers for why we established this award was to provide education to members of the bar, particularly younger members, about the practice of environmental law and also the history of environmental law in California. So we really appreciate Clem being willing to come and talk with us tonight. So with that, I will turn it over to our three stellar stars up here. Thank you.
Thank you, Marilee.
Good evening, everyone. It's wonderful to be here, and it's truly an honor to be sitting up here with Tom and Clem. And we welcome you all. This is our first event, and to see an already full standing room, almost, yeah, there are some standing, is really wonderful. So thank you for being here. I would like to thank Marilee and Mark for all the work they put into not only on the committee, but making this event happen. It's hard to make an event for an established conference, a new event, a new venue, figuring out how to make the logistics work, and they've really worked hard to make that happen, so thank you. We've spent over the last several weeks many conversations, correspondence, and trying to find the questions that Clem was interested in, the things that would be interesting to you. And we're very excited about this conversation tonight. We've divided up questions in 3 general topics. First, the big picture, the development of environmental law in California, Clem's ideas for good lawyering, and then how it is to make a career in environmental law. We'll try to get to all the questions you may have, but if you do have others, please do pass them around and we'll do our best to get to them. And with that, Tom is going to introduce Clem.
Great, thank you. Thank you very much, Jane, Marilee, Mark, other members of our committee who are here. And thank you for arranging to pack the house by having a number of your lawyers from your firm here, Clem. Very clever of you to do so. And I'm looking around the room and thinking of all the environmental knowledge there is in this room. It's pretty extraordinary. So I do want to encourage you to let us know if you have any questions, just in terms of getting this to run as smoothly as possible and to make it as much time as Clem talks and not us. We have these cards here, so you can get them from Mark and from Marilee or from us if you want to have a question. We will try to run this right till about 6:15. We have about 45 minutes. We may go as late as 6:30. We'll see how it flows. We have a full hour of video time. We will eventually have to close this down, and you will probably still have some questions left over. So Clem has kindly volunteered to stay here with us, and we can have a smaller group to do that. My other job was just to tell you a little bit about the selection process, and I think in the interest of time, I'll just tell you that it was very painstaking and careful, and Jane or Mark or Marilyn, I'd be happy to talk to you about it if you have some ideas for nominating people for this process. But it's a real treat to be able to introduce Clem, and the good news is that you can read all about it right here on the piece of paper that's with you, and it's really an extraordinary career in environmental law from 1964 to 1980 at the California AG's office, and then at the Shute, Mahaley, and Weinberger firm since then. The number of cases and the number of issues that Clem has worked on over the years is extraordinary, and given that knowledge, and it is fair to say that his life spans modern environmental law, we thought it would just be great to cover the subjects that Jane's already mentioned. So having said that, I'm going to turn right back over to Jane for our first question.
Okay, we're going to start with the big picture. Clem, how do you view the development of environmental law in California? Specifically, we know you were deeply involved in the early development of CEQA. Perhaps you could share that experience and how you saw CEQA evolve over your career. And please, include the good, the bad, and the ugly.
Well, thank you. First of all, it's a great honor to receive this award. It's humbling. I've had a lot of chance to, I'm not retrospective by nature, and I've had an opportunity to think back on some of the things that I've done and relive them, and it's been kind of fun. Also, the audience is stacked because there's a lot of members of the law firm, members of my family, and I know a lot of you, so this can be pretty informal. What I want to do is talk a little bit about history, because history is important. This is being recorded, and even though some of us live this, it'll get forgotten over time. And I also know that retrospectives can be not useful to practicing lawyers, so I'm going to try and make sure there's some things for thought or things useful for the future in what I talk about. But I want to talk about CEQA in some detail to answer this question, and I want to start off with the context. You know, in the early mid-1960s, there was a lot of furor. This was really the beginning of the environmental awareness in the United States. The Sierra Club was fought the Glen Canyon Dam, not successfully, but it was a major issue. There was a Santa Barbara oil spill in 1969 that got a whole lot of attention. There was the Rachel Carson's book, DDT, The Silent Spring, and a lot of concern about filling of San Francisco Bay so that it would someday be called San Francisco River. And that led to the enactment of a number of laws in California. In 1965, the Bay Conservation and Development Commission, BCDC, was enacted. In 1969, the first bi-state compact between California and Nevada created the Tahoe Regional Planning Agency, and by initiative in 1972, when the legislature failed to do anything, the California Coastal Commission was created by enactment of the people. So there was a lot of furor at that time, and in the middle of that, in 1970, CEQA was enacted. And it was a little known, unimportant, not controversial statute in the legislature. The legislators thought they were copying NEPA. There was this new National Environmental Policy Act. It would call for some kind of environmental study on large projects. Why not have the same thing in California? And so it was passed without much fanfare and without much legislative history, without much debate. And it was pretty much universally thought that the statute said it applied to projects they carry out, referring to government agencies. So everyone thought it referred to public works projects like freeways or dams and not government regulation. Well, there was in the Attorney General's office, created by a moderate Republican, some of you remember what those were, Evel Younger, and he created an environmental unit, 8 of us, Jan Chapman Brown, who I saw a moment ago, over you moved, and Mark Mahaly, and my, geez, wow, it's more stacked than I thought. I'll have to be careful if I be correct here. Anyway, he would tell us, I don't know what you guys do. I don't understand what your theories are, but you get my name in the paper, make me look good, so go do it. And so in the early years, before he decided to run for governor and pretty much shut us off, we had a lot of free reign. And this case was filed in Mono County by a local judge, a local lawyer, Friends of Mammoth it ended up being. He was representing the Friends of Mammoth. And he had this theory, it wasn't very well formed, that CEQA applied to government regulation of private projects. And we latched onto that. The environmental unit latched onto that. And we shepherded that case and helped to get it to the state Supreme Court. And we wrote, I think it was an 80-page brief, arguing why the law, with all its broad findings and broad intent, should cover regulation of private projects as well as government projects. The establishment thought that was pretty far-reaching, and even an esteemed scholar here, sitting in the back row, Mr. Selmy, thought it was a stretch. It's being taped, Dan. Well, as you all know, and nobody thinks back on it now, I don't think, you take it for granted, the California Supreme Court ruled that it does, in fact, apply to private projects. It literally stopped construction in the state of California. All the lenders said, hey, no more money, you know, everybody's project's illegal, we don't know what's going on. It made the front page of cover of Time magazine. It was a big deal. And the legislature reacted in 2 months, can you believe that? Between September and November. And there's a lot of pressure on both sides, and rewrote the statute to pretty much what it is today. There's a lot of nuances that have been added, but it's pretty much what it is today. And on the one hand, the Supreme Court decision was there. The environmentalists had that as leverage. The developers were pushing to try to cut back on that. That wasn't going to go anywhere. So the law passed with short statutes of limitations, but the basic core definition of project was changed to make it apply to public projects. So today, I've lost count. I gave a talk at UC Davis a couple years ago, and at that time there were almost 300 published opinions. I'm sure by now there are 400 or more. You can imagine how many unpublished or how many trial court decisions there are. So from absolutely nothing in a period of less than 50 years, we have a mature body of law. And you know, you have to pretty much know what you're doing now to file a CEQA case or defend a CEQA case. It's not something you can just sort of pick up. It's kind of like, I wouldn't try to incorporate anybody because I don't understand that. Same thing for CEQA. So what's good about this? Well, at a grand scale, there's thousands of projects that didn't happen because they were delayed or they were stalled or they were stopped because of environmental considerations. There were thousands of projects where the impacts were mitigated or alternatives were chosen that had less impact, so it was more beneficial for the environment. And the whole idea that the environment has to be considered in making decisions is now taken for granted. It was said earlier by somebody as we were getting started. Now nobody questions that. I mean, we all can argue about whether that's effective in any given circumstance, but that's the culture now. Nobody doubts it. And I really think that CEQA has also leveled the playing field. And land use is a big part of the focus of CEQA and a big part of the focus of environmental law, certainly in the early days. And people who wanted to challenge the land use approval pretty much had to argue that it was arbitrary or capricious because unless they could say you didn't give notice or something fundamental, it was hard to win. To say, well, it was arbitrary to allow that liquor store in that corner. Yeah, well, we decided it was in the public good. Who's the court to second guess that? Well, CEQA changed all that because it gave people an opportunity to argue on a procedural ground. You didn't study this, you didn't look at this, you didn't pay enough attention to that. And to me, because from the beginning I was a little skeptical that the courts would really get excited about reviewing hundreds of pages of environmental documents and saying, oh yeah, that mitigation isn't real. But they did, and they have. And so that has made it much easier for petitioners to challenge cases. So government agencies know that, developers know that, and so a lot of planning is much improved because even though there may not be a lawsuit, people are a little more careful about what they propose because they know that they're being watched, or it's very, in situations where I know there's no chance of a lawsuit, you hear a developer say, well, I'm worried about a lawsuit, I'm worried about who's going to sue me. So it does have that beneficial effect. And what I want to say about Friends of Mammoth, which started all of this, is if it wasn't for that small group of lawyers in the AG's office, it might not have happened. And so I just want history to record that. So what's bad? I'm going to combine bad and ugly because that's a shading that I have trouble with. Well, I'm going to say some things that some of the people here in the room won't like. Good projects can be killed just by the passage of time that it takes to litigate. Now, some of us in the early days advocated an environmental court. Whether it would have 3 judges or 1 judge or a roving panel or whatever, these would be people like people in this room who have expertise, could hear these cases, they'd be much more expedited, and the results would probably be more rational. A lot of trial judges I've argued in front of, they've gone to sleep in the middle of the arguments, and they're criminal judges and they don't know and they don't care. But that idea never got any traction. So what we have is a system that takes a long time to litigate, a lot of hassling about the administrative record and other things. So good projects can just be killed because the passage of time. And it has also become, in this modern day of lending and financing, that the filing of a CEQA suit can stop it just because people won't lend money. And so you get an injunction just by filing. And I'm not sure in the long run that that's really good. And then you also have the situation where CEQA has been misused by people who really don't care about the environment. I know of situations, and I'm sure you all do, where a competitor will find a front group to litigate in order to stop a competitor from building a landfill or something like that. They could care less about CEQA or the environment. There are other groups that have used CEQA as leverage for objectives that have nothing to do with environmental protection. So that's the good, bad, and the ugly. So people will say, what should happen? Well, that's way too big a subject for tonight, but I do know that a frontal assault on CEQA, which is what people like to do, they like to go to the legislature and hope they're going to hammer this thing into oblivion. I have from no less an expert than the governor of the state of California, Jerry Brown, it ain't going to happen. He's not a big CEQA fan, but you know, he has said that there is no chance that there's going to be major destruction to that statute as much as he might like it, because it's got too much political force behind it, too much institutional culture behind it. So if people would give up the frontal assault and work on fine-tuning and around the edges, I think it would be wonderful. For example, to me, the whole business about administrative record preparation and the fighting that goes on over that is stupid, because most of the time you have 1 or 2 documents in the administrative record you care about, and the rest of it's just old studies and old stuff, and oh, it's got to be in there. And there's got to be a way to streamline that and avoid the time and effort and fighting that goes into that, and other things like baseline and whatever that could be worked on if people of goodwill just sat down and tried to hammer out some of those things. So the long and short of it is CEQA is part of our history, institution. It's going to go forward that way, and it overall has been a fabulous benefit, and it's been, to me, the reason environmental law really took a jump start in California, Friends of Mammoth.
Well, that's a great segue into our next question, Clem, but you should know that a good chunk of the panels at this conference have already discussed CEQA.
I have no doubt about that.
So the prophecy leads on. CEQA is just one of a number of environmental statutes that really were sort of given birth and strength here in California. Some thoughts on why California, in addition to just being a beautiful place and having a lot of people, was the birthplace of so much modern environmental law?
Well, I've thought about that at several different levels. At sort of a cultural level, California's population, I think, is generally more progressive than Alabama. And so a lot of it is just that the politics here make it a little bit easier to get these kind of laws passed. Remember, Ronald Reagan signed the CEQA bill. So all those Republicans are running around talking about Reagan. He did sign the Coastal Act, not the Coastal Act, but a lot of environmental legislation in California. So we have Prop 20 was created by the people. We've had environmental initiatives enacted by initiative, and it continues. We had AB 32 the last several years on climate change, so it's still possible to get strong environmental legislation passed because of the public will. That's probably the most important factor. But at a legalistic level, at a legal level, with more interest to lawyers perhaps, is the role of the California Supreme Court. In the 70s and so, we had Chief Justice Traynor, then Chief Justice Rose Bird, and a lot of people criticized that court for being too activist, too liberal, too whatever. But from an environmental point of view, they decided, not only Friends of Mammoth, but the National Audubon case, which blended public trust and water rights, a whole lot of ground-breaking, huge impact cases. So I think the role of the California Supreme Court in this has been pretty important. Another thing that I think is important is if you can breathe on a knife and it leaves mist on the blade, you can bring a lawsuit in California. And for the non-lawyers, that means standing. And we don't, you take by contrast the federal system, which has all kinds of zone of interest. I can't even remember it all, but it's very hard to bring a case in federal court without showing that you're directly harmed, that your organization is, and so forth. In California, you have none of that. And so it's much easier for a petitioner to take a flyer and bring a case, and claims that sometimes would seem remote but end up being substantial are able to be brought to them, concluded on the merits, and sometimes they prevail. And that's not as easily done in most other states, and certainly not in the federal system. And then the third thing to me is legal fees. Now, first of all, what pretty much is common throughout the United States is that loser does not pay. Just think if loser had to pay fees. That's the system in the United Kingdom. You wouldn't have Brown versus the Board of Education, because who's going to sue a major government agency or private party and end up having to pay their lawyers' fees? So you don't get reform or social or progressive litigation. So that's one thing, but that can happen in other places beside California. But in California, we have CCP section 1021.5, and maybe some of the old timers can tell me what year that was. I think it was 72, but I'm not sure. Anyway, that's been on the books a long time. It's called the Private Attorney General Doctrine, and allows private parties to act as if they were the Attorney General, and if they enforce a public law, they are entitled to fees. So what does that do? It gives a whole lot of people an opportunity to bring litigation without the risk of paying if they lose, and with the prospect of succeeding and getting fees if they win, and oftentimes settlements where nobody actually won, but the settlement involves the payment of fees to the prevailing party. So I think that means that in any given controversy, there's a much greater chance that there could be litigation, because there'll be somebody willing to take that case on a contingency, so to speak, or evaluate that it has a pretty good chance of success and proceed with it. And I don't think there are too many other states that have that kind of a statute. And so those are the reasons that I think California's been in the lead.
Thank you. Jane?
Okay. So obviously your career has spanned several decades, and including when environmental law in the nation and in California was in its infancy. How did you view environmental law at the beginning of your career, and how has your perspective changed over time? And in that, what do you see as the pivotal laws and cases that have affected your view as over time?
Well, when I started off in the Attorney General's office, and the San Francisco Bay Conservation Development Commission law, McAteer-Petrus Act, was passed in 1965. I had taken every tax course I could take. I was going to be a tax lawyer. Thank God that didn't work out. And so one day, the Attorney General by law is counsel to all state agencies. This was a new state agency, and people walked up and down the hall, the management, and said, there's this new agency. They're supposed to deal with Phil in San Francisco Bay. We don't know what the hell they're supposed to do. Who wants to volunteer to be their lawyer? So that sounds interesting. I'll do that. So I volunteered. So it was almost by happenstance. I remember my dad telling me one time, you won't end up doing anything that you thought you planned to do. And he was right, at least in my instance. Well, there was no environmental law then. There was no cases. There were no treatises. There were no law school classes. I remember going to conferences where people debated, shall we call ourselves conservationists or environmentalists? And the irony of that is a conservationist comes out a conservative. And the people who were arguing for that were arguing that environmental protection is a conservative principle. It preserves our resources. We should all be in favor of it. Well, how'd that turn out from definition of the word today? But anyway, so it was sort of make it up as you go. And in the early days, a whole lot of the emphasis was on land use. Because planning and all was seen as the primary way, and in development projects, the primary way that the environment was impacted. So the Bay Conservation Development Commission was created to stop bay fill. And over time has done a fabulous job in doing that. But at the start, it had to fight every local agency who said, who are these guys to tell us what to do? In California, local governments are sovereign when it comes to land use. And some of the early battles that we had to fight, you might not even consider environmental. They were battles like, does a regional agency or a state agency have the power to override a local land use decision? Believe it or not, that was a big issue. And the Tahoe Regional Planning Agency was created in 1969, and the funding was supposed to come from the local California counties and Nevada counties from property tax. Well, they said, the hell with that. We're not going to pay it. What are they going to do now? So they could hire no staff. They couldn't do anything. So they came to us, the Attorney General's office, and what are you going to do about it? So we thought, well, you know, we don't have time to fool around in the lower courts. It'll take forever. We'll take a flyer, filed an original petition in the California Supreme Court to mandate that the counties pay their dues or their funding requirement to the TRPA. What was the argument? The TRPA is an intrusion on local government, an intrusion on the prerogative and the sovereignty under the California Constitution of local government to make land use decisions. The California Supreme Court said no. Anything affected by a state interest or a regional interest overrides local interests, pay the bills. So, you know, you took the cases and you moved things in the direction that you needed with whatever the crisis was at the moment. A very, very significant development was the Coastal Act in 1972. But there were efforts to get that bill passed in the legislature, and they failed. So Peter Douglas, some of you know him, took the strongest version of any bill that had ever been introduced in the legislature and put it on the ballot. So much for that. If you don't want to compromise in the legislature, you're going to get more. So the public didn't know between the nuances of regional commissions and where the line was and what the powers would be, and it passed. And I can't imagine what the California coastline would look like today without the Coastal Commission. So to me, that was a major development. Another thing that was really important in early environmental law and continuing up to maybe the early 2000s is regulatory inverse condemnation. We were constantly at one time there were 30 cases pending against TRPA claiming that their actions had taken private property and they were entitled to just compensation. And from Penn Central in 1978 to Egan's in 1980, from Egan's until Tahoe Sierra Preservation in 2002, every decision went for the property owner or the government. And that had its effect on public access, on temporary takings, and so that has been a big battle. Now my sense is that it's still out there, but it doesn't have the fiery furor behind it that it used to have. So land use was a big early emphasis. Today, of course, one of the marvels of environmental law is contaminated property, air quality, water quality, the blending under the National Audubon Society of Public Trust and water rights, I think has made it easier for the state to cut back on water rights during the drought, because those rights used to be considered vested. And now under public trust doctrine, the state has a right to step in and modify those rights. And of course, who would have foreseen even 10 or 15 years ago the whole thing with climate change? And AB 32 leading to SB 375. The face of California over time is going to be different because of those laws. I mean, with the idea that you have to have compact growth and reduce greenhouse gas emissions, that's going to change the way urban areas look, and it hopefully will increase the ability to protect rural open space areas. So environmental law has moved rapidly in many directions, has many fingers. It's no longer possible to say that I'm an environmental lawyer. What? Contaminated property, land use, land conservation, land conservancies, climate change. I mean, it has so many facets to it. And it will continue to become more complex and probably more creeping into more areas than we can imagine, even as time goes on.
Can I go next? Clem? We'll
Yeah.
go to good lawyering. I mean, first of all, we're all happy you didn't become a tax lawyer. That really pleased us. The next section we wanted to cover that Jane mentioned was ideas for good lawyering. And this was something, interestingly, that Clem asked us to cover, which I thought was great. And there's some extremely good lawyers in this room. I doubt there's that much we can tell them.
Yes, right.
But for those of us who are still learning to be good lawyers, like me and Jane, is there a skill set for a good environmental lawyer that's any different from just being a good lawyer? And I think that's something we wanted to share. Have you share your thoughts on that?
Well, with all due respect to the audience looking around, there aren't that many folks that look like they should be carded when they walk into a bar.
That was extremely polite of you. That was very well done.
So this may be for the benefit of the tape and posterity. And I think a lot of you know this, but it's one of my favorite subjects in talking to young lawyers or teaching in law school. A traditional lawyer has to know the statutes, the cases, the strength of their position. They have to have some basic negotiating skills. To me, environmental law is very different from that. You have to have all of those skills, but in addition to that, most of, at least in my practice or my experience, we spend a lot of time dealing with non-lawyers. You're in front of commissions and boards and planning commissions that aren't lawyers. In fact, a lot of them don't even like to see lawyers up there. So one of your challenges is how to come across as not being a jerk. And so you need to develop, and I've learned a lot of this from Mr. Dean Mahali right here, that you need to learn to read body language, understand at a much deeper level what your opposition or the people you're talking to, what's really motivating them, what are they thinking, how can you best fashion your position to be effective in dealing with them. And I'm going to give an example that seems a little bit attenuated, but I was representing the East Bay Regional Park District a few years ago in the 90s, trying to develop a park along the East Bay shoreline. And the lead was state parks. They had the money, and it was supposed to be a state park. Well, they kept telling us that they didn't want to do an urban park, and so they wouldn't move on this project at all. And it just struck me that that wasn't really right. They had other parks that were urban parks. They had Candlestick Park over on the other side of the bay. So I dug around and found out that they had been burned in a whole bunch of eminent domain cases in the recent past, where they had gone try to acquire property in urban areas, and the juries had come in with really high awards. So they didn't want to do that anymore. So once we figured that out, we went to the legislature and gave the lead to the East Bay Regional Park District, who wasn't afraid to use the power of eminent domain. Well, there's a park there today, and we never had to use the power of eminent domain because that threat was enough to provoke a negotiation. So that's an example of just going beyond what people say to what is really going on. And I think that's when you stand up in front of a city council of lay people, they're motivated by re-election, by whether they have any relationship with the developer or with the people opposing the project. You need to understand all of that in order to be effective. So that's my shtick on that one.
Thank you.
So maybe as an extension of that is, in a more general sense, what is good lawyering? And what suggestions do you have for us all here for good lawyering, and what does it mean?
Well, I'd be interested in reactions, later on, but I have observed the practice of law over my time to have become more nasty, mercenary, and too much about money. And I have to think that there's a school somewhere that teach people how to be assholes, and the lawyers are the students. It just strikes me. And, law is a profession, it's not a street fight. And I just think that there should be a lot more respect among lawyers dealing with each other. You don't have to be a jerk to protect your position or advance your position. And again, I'm going to give an interesting example. I was in a federal trial in 1999, and I'm pretty familiar with state rules of evidence, but the federal rules. And in the middle of this trial, the witness said it was going to answer a question. I thought, oh, so I objected. And there's this crusty federal judge who said, all right, counsel, what's the basis of your objection? Well, I hadn't a clue. and all of a sudden, this book comes over with a finger pointing at a rule. It's the opposing lawyer. And he said, right here. So, well, Your Honor, Rule 52.6, up, sustained. So there's an example to me of professionalism. Did that cost him the case? No, he won the trial. We had to beat him on appeal. But it didn't cost him the case. And, I think there's a lot to that. Rather than saying, somebody calls you up for an extension, screw you, ask the court. I don't have time to talk to you. Don't do it. Take the high road. It'll all come back on you sooner or later. And so that's a primary piece of advice that I have. Other thoughts. Preparation, and I have another great example for that. It avoids stress, anxiety, and failure, being prepared. I was fortunate enough to be able to argue the Egan's case in 1980 in the U.S. Supreme Court, and that was a case that involved a minimum 5-acre zoning requirement in Tiburon, California, a suburban town. And about 3 hours before the oral argument, Mark Mahaly comes, we're having breakfast, and he comes in and he says, you know what? He says, what if one of them says, well, it's all right, Mr. Shute, to have this kind of 5-acre thing in some suburban town in California. What if you had that ordinance in Manhattan, New York City? About 3 hours later, one of the justices leaned over and says, Mr. Shute, this might be fine in Tiburon, wherever that is, but what about New York City? And it was the precise question, almost in the same wording that we had thought about it, and I don't even remember the answer, but we worked. And to me, that's a great example of being prepared. It will save you a lot. If you're up there and you know you're prepared, you're not going to get thrown. Or if you're in front of a commission and you've really done your homework, you're not going to get thrown by anything. And people can tell when you're uncertain. I mean, it's pretty hard to hide that. And then another thing which I think I'd like to mention is writing clearly and with as much brevity as possible, and putting your conclusions, or at least having a summary of them early. I mean, I don't know how many papers I've had to read, or memos, or briefs where, where's the point? And everybody's busy these days, and they don't have time for it, particularly lay people. You give them a memo to a client, or you're writing an argument to a commission, you want to have right up there in the front. What is it you're trying to make? What's your point? And I really feel it's important to concentrate on being precise, getting your point up there early. And I guess the last thing I'd like to say is I've seen that increasingly in environmental law, people work with other disciplines. You have to work with other disciplines because you work with a geologist or an architect or some other discipline on a project, either as an opponent, developing expert testimony, or as a supporter, putting together your package. And you need to be able to work with them, particularly if they're expert witnesses. You have to understand how far they're willing to go or what they're willing to say, and not try to I've seen many lawyers try to badger an expert into saying something that's way beyond their zone of comfort, and that's not productive. So when you have the opportunity, I think the future of education is going to be more interdisciplinary too, because the lines are blurring between all these various professions. And so working with others, I think, is important.
Clem, thank you for that. Just for anybody who joined us a little later, we are going to take some questions, but we're going to ask you to put your questions on an index card. I'll pass a few out over here and a few out over here if anybody has any. You can hand your cards to Mark or to Marilee, who are right here. They'll pass them to Jane and me, and we'll Do write them in a legible fashion so we can read them. We wanted to move things along. I'm still intrigued because I grew up in Manhattan about what 5-acre zoning would be like. So I'm gonna think a little bit about that. But our last section that we're going to talk about with Clem is making a career in environmental law. And one of the things we wanted to ask him about is, how would you recommend to students, law students and those beginning their legal careers, what areas to go into? Do you start in government? Do you start in private practice, nonprofit, otherwise? What are your thoughts on that, Clem?
Well, first of all, I think that if somebody's really sincerely interested in environmental law, they need to show that interest by things that they've done, either classes that they've taken or activities that they've pursued. I've had people come to me who are probably very fine lawyers and say, I want to get into environmental law. There's nothing in their background or nothing that they've done that shows that that's an interest. And face it, it is a passion. It's not just something you do to earn a living. And so you have to show the interest. But then beyond that, and again, this is probably more for the camera than anybody here, I think it's really a great way to start is in public service someplace, because they're always understaffed and you get thrown in a hurry, whether you're at a city attorney's office, the attorney general, district attorney. When I was representing BCDC, we had some major cases, and I ended up arguing. I was admitted to the bar in '65. I was in front of Chief Justice Traynor arguing in the state Supreme Court in 1967. Now try that at a big law firm. So I think public service is a good way to start, and you don't get penalized for being in public service. You can always find a job with a big firm, a nonprofit, whatever. People will take it as an advantage that you've served in a public agency and seen the fights that go on from a different perspective. Now, one thing that I have to add to that, because I've suffered this personally, is that quite often in public service, what sounds good and works good isn't going to last over the long term, because you may work with a city council that really likes you and you like what they're doing, you like the general plan that they're developing, you like their outlook, and then the next election or two it all changes and all of a sudden you're persona non grata, and they don't want to hear you and they're looking for a way to fire you. Or in my case, the Attorney General changes from a moderate Republican who liked environmental protection to a right-wing nut Republican who abolished, and that's okay for the tape because the guy had the range of an insect for intellect. He abolished the program, and so that I was running and that Mark was part of, and so the choice was to stick it out, because it wasn't like you got fired, you just got assigned to another section. But do you want to do that? So if you're going to go into public service, I think you really should always be thinking about a plan B, because I think at some point the politics will change and you will find yourself being in an uncomfortable position. Also, I found a lot of people that have gone to law school will realize over time that they really don't want to practice law. They want to do policy. And law is a great way to be disciplined and learn thinking and writing to do good policy work. So I would encourage young people to think about, all right, do I want to work in public service, a nonprofit, a big firm, a small firm, my hometown? But also think about using your legal experience or knowledge to work in a non-legal job. And that can be just as rewarding as anything else. So that's...
Okay. Thank you. We've got several questions coming in. We do have one more question that we had prepared, and that's for the lawyer who's been out a while. How does an environmental lawyer evaluate where he or she is in his or her career, whether it's right, and what could they do about it?
Well, a career usually lasts, several decades, 30, 40 years plus. Now, some people don't want to work that long or won't for a whole lot of personal reasons, but as a general rule. So I think it's important not to get stuck in a position where you become cynical or burn out early on because you don't like what you're doing and you haven't thought about what to do about it. So my advice is that after you've started any job, you should take a period of time, like 1 year or 3 years, set a goal and evaluate where you are. Do you like it or don't you like it? And what are your choices? Because I know people who for years have told me, I don't like my job, it's terrible, I'm going to change, and they never do. because they never put themselves to the discipline of saying, all right, I've had it here. What am I going to do? What are my choices? And your choices may not be evident to you right away, but you think about it over time and something will come to you. And I always say to people that are in that position, do you know many lawyers that have gone bankrupt? I don't. So you usually have choices even though you think you don't have choices. And I also have learned that lawyers, surprisingly, are risk averse. And so you may be unhappy in a job, but not unhappy enough to do something about it. Now, I was unhappy enough and sort of forced to do something about it. I really don't know what I would have done if I wasn't forced to do it because I felt uncomfortable walking into the office every day after having been basically fired. But people who just don't like what they're doing, they have a much harder time coming to a point of saying, you know, this isn't working, what am I going to do? And the only way I know of or have thought of to deal with that is to have a point where you sit down with yourself or whoever you want to talk to, family, and do a serious evaluation and then develop your alternatives. They'll come. The economy the last few years hasn't been so great for young folks getting into the business or people changing jobs, but that changes, that's in cycles, and you will have your opportunity. So I say don't be miserable, you know, work your way into something that you enjoy doing because you're going to be doing it a long time.
Clem, thank you. That's terrific. We've got a couple of really great questions that have come in.
And this first question actually I think is a segue from what you were just saying. Speaking of mid-career or changing jobs, can you tell us a bit about the formation of your law firm?
Well, Mark Weinberger, who passed away 6 or 7 years ago, Mark Mahaly and I were in the environmental unit, and I was their boss. That's one of the hard things about going into a partnership. You suddenly can't tell them what to do anymore. But we decided that we wanted to form a law firm, and we wanted to do good where we could, environmental good where we could. We wanted to try to continue the environmental unit notion of representing public agencies, but also doing citizen work, representing Sierra Club or groups like that, regional groups or local groups like that. And so we started off with that as a business model. And we spent several weekends, people would loan us cabins, and we'd go off and think about it and do a business plan, think about what it is we wanted to do. And so we started off with the three of us and a secretary. And the first thing that happened is every developer that we'd ever walked over or kicked around called us up and said, hey, I'm going to help us out. And when you leave public service, you don't take your clients with you. I mean, I've always, these lawyers who say, well, I changed firms. Well, big deal, you took your clients with you. You don't do that from a nonprofit or a government service. So we had to start from scratch. And because we'd thought about it, we said no to every single one of those inquiries, which can be hard. You know, my two daughters who are now fully grown were getting ready to go to college. These two guys had nothing of any value, so to get a line of credit to start the firm, we had to put a mortgage on my house. And so there was a lot at risk, but we felt strongly that we wanted to do it the way we wanted to do it, and we would either fail or not, and we didn't. So if you're thinking about going into sole practice or setting up a practice or going into a practice to emphasize environmental law, develop a plan, a model. Who do you think your clients should be? What are your strengths? And also, if you're working with a group, like the two Marks and me, each of you will have different strengths. You know, Mark Mahaly's the visionary. He would sit down and, what are we going to be like in 5 years? Like, who cares? You know? And Mark Weinberger, we're going to negotiate the lease. I'm going to squash that landlord. And I'd say, I'm looking at the check balance, man. Are we got any money in the bank? And so you split up your talents, and that helps a whole lot when you're running an organization. So that's how we started. And you know, as you can tell by the number of folks in the firm in the room, we've done pretty well.
So I know Tom's chomping at the bit to ask the next question, but I'm going to keep going. So this is actually I love this question because I actually asked this question of Clem as we were driving over here together tonight. Clem, when you formed your law firm, Shute, Mahaly and Weinberger, what vision did you have for the future of the firm, and are you surprised about what the firm has become?
Well, I think that we had a pretty strong business model, isn't quite right, but objective of combining representing public agencies and citizens groups. And we had learned from the Attorney General's office that there are a lot of public agencies who were fighting the good environmental fight in any particular circumstance. So the idea that government is always bad or neutral wasn't the case. And we knew that there would be instances where cities would be fighting something that the city next door wanted to do that impacted them, or a city was going to fight an airport that was expanding and hurt their citizenry. So we knew that was out there. We also knew that there were plenty of citizens groups that wanted to be represented. The conventional wisdom was they won't pay their bills, and that'll be hard. And we decided that we were not going to rely on CCP 1021.5. We were not going to take contingent fee cases. We were going to take cases that people paid, the rate might be low, might be all they could afford to pay, but we were going to do it that way. And we stuck with that. And one of the things I'm most proud of is that the second generation of leadership is doing the same thing.
Great. Can I go ahead, Jane? So
guess so.
I think we're going to go for maybe another 5 minutes or so. That's right.
Are
We
we
okay
good
for
on
time? Yep, we're okay. Good. So I have two somewhat linked CEQA questions, and we're being asked to be a little louder because we're getting a little competition from the bar here. One is from one of your former partners, but I think I'll give you both questions and you figure out how you want to answer them. The first has to do with the end run around CEQA by using an initiative. So any thoughts on that? And the second is, we tried to give CEQA a substantive pro-environmental aspect as opposed to a purely procedural one, and failed. Should we have succeeded? Later on, you can guess who wrote that question.
Well, again, there was a footnote 8 in Mammoth, Friends of Mammoth, was suggested that maybe these environmentally superior alternative had to be selected. So that started to be the foment, and the legislature put the quash on that. I think that's a long conversation. I don't know how I feel about that, because the environmentally superior alternative may be that from the environment, but there are other considerations social considerations and all that are important. And so to end up having CEQA be trump everything else, or the environment trump everything else, I might like it 90% of the time, but I'm not sure it's the right thing to do. And as far as end runs around CEQA initiatives, that's gotten to be a technical area too. Did the city council first have something that was a proposed action and then they didn't take it, and then somebody picks it up as a referendum or initiative? And I really don't. I don't want to comment on that.
Okay. Well, CEQA lives on, clearly.
I've stopped going to the office every day, and so I'm not up on the details of things that are happening right now.
Great. Jane may have one or two more.
I have a few. Let's see. Well, this actually kind of goes into why you were selected for the Lifetime Achievement Award. So the question, and I'm going to read it literally: be humble, but without you, what would California look like right now? Be humble.
Did one of your grandchildren put that question in? Yeah, they might have.
Well, okay. The town of Emeryville wanted to extend into the bay. For those of you who know, there's a marina out there now and an arm. They wanted to put 150 or 60 acres of bay fill out there and build a city for 15,000 people. And we, on behalf of the Bay Conservation Commission, they claimed they were grandfathered. We argued they weren't. And that went to the California Supreme Court, which we prevailed. And I was terrified, because I thought, for the rest of my life, if I lose driving across the Bay Bridge, I'm going to have to look at that city. It's not there, because we were able to prevail. There were 2 high-rise office buildings proposed in San Francisco Bay by the Bay Bridge, U.S. Steel and Ferryport Plaza, the height of the Bank of America, on bay fill. And they had this argument: we are going to remove as much fill as we're putting in, so it doesn't have to be water-oriented, because it's net wash. And I wrote an Attorney General's opinion that said, no, fill is fill. It has to be for the purpose prescribed by the law. The commission turned the projects down. They were litigated, and we prevailed. So there are 2 high-rises that aren't there. There's lots of land around the state that have been involved in protecting. There are a lot of people living around airports that don't suffer as much noise. because of things that I've done. So I'm proud of what I've been able to accomplish.
Here were casinos in Tahoe.
Yeah. Oh, Zan and I know about that. We filed a suit against a casino builder at Lake Tahoe, and we had to go over to the federal court in Nevada to argue that. And we had a tough time. We got it wasn't from Justice Douglas. We had a stay of construction, and then the court required us to put up a bond. So we went to the Attorney General and said, hey, we're going to win this case. Let's put up a bond, and then we'll be able to pursue it. Are you kidding? We are not putting up any bond. And we lost, so probably a good thing we didn't. But that property, because of the hassle that we gave them, it's now open space. No casino was ever built. And that happens a lot. You might lose that project, but in the meantime, they've lost their financing, they've lost their interest, the ownership changed, somebody died, and it ends up being bought by a conservancy or protected. So
I think that says it all right there. And I would like to say, on behalf of everyone in this room, and the committee of the State Bar, Executive Committee, and the Lifetime Achievement Award Committee, thank you, Clem.
Thank you very much. I think we're off the record now, Clem, so you can say whatever you want.
no, I still got this thing taped.
There we go. that was terrific. That was really interesting and fun for people,
Thank
I
you.
thought. Yeah. Just what we were hoping, I think, right, Jane? That was really terrific, yeah.
It was fantastic. And thank